We've spent 4 years on this matter, and today we are happy that the matter has come to conclusion, and the verdict to acquit us is something we want to say we are happy about. But also, let me say that it was quite unfortunate that a good program that was meant to empower the youth of Uasin Gishu County was actually interfered for political reasons, just because some people think you can destroy programs so that you can destroy other people's political careers.
Come again. Come again.
I want to say that the program was an open program, and I'm proud of that program because, as we speak today, Uasin Gishu County has more than 350 students in Finland, and about 100 students in Canada. The most unfortunate thing is that if the program was continuing, by now, probably we would be having more than 2,000 students from our county in those countries. Let me say that the verdict that has been rendered today was to clear us from the allegation that we abused office, that we stole money, which was not the case. I also want to say categorically that I left office when the program was running on the 22nd of August 2022, and by that time, that account that was cited in court had an amount of 108 million in that account. After I left, more than 60-70 students also still proceeded to travel for overseas studies and also to seek employment opportunities. I'm consciously aware that the parents whose children didn't travel and their money was spent on other children still need to get their money back.
Yes.
And this verdict affords us the opportunity to now pursue those parents and children who were paid for by the trust using funds that were meant for other children, and whose approval was done when I had already left office, that they must take responsibility. They cannot today be enjoying permanent houses that have been built by those children. Some are driving. Some have even achieved their wildest dream of traveling all the way to Finland, a dream they would never have had if the children would not have gone to Finland. I therefore want to urge the beneficiaries who know themselves and who know they benefited from the program and who are supported and they are enjoying the benefits of the program, that they should speak to their conscience and refund the money to the trust so that those parents who are suffering out there can get their money. Number 3, the politics of the program now is over.
Yes.
We want to urge the county government of Uasin Gishu, because that is a county program, to take responsibility and follow up and make sure that those parents are refunded. Finally, let me thank my legal team, Wakili Kibet, Wakili Limo, Wakili Jebon, Wakili Kibungei, and all our other legal experts who worked with us in this journey. I also want to thank the people of Uasin Gishu, our supporters, all who are here, who have consistently, for the 4 years, We have had people who have spent their resources and their time to travel to Nakuru to stand with us for the 4 years. I want to thank you and tell you we are on course when it comes to matters developing our county, standing with our people. We shall stand firmly behind the people of Uasin Gishu so that they can get development. So we are committed to the cause, and we want to make sure that we succeed as a county. And I want to encourage the young people of our county
Long live! Long live the king! Long live Senator!
that we shall continue to work together, even in achieving more than what we can. It is my sincere hope that the county government of Uasin Gishu, led by Governor B, can now reconcile their thoughts and conscience so that they can restart the program and ensure the people of Uasin Gishu are benefiting. This is a program that is well in line with the UDA manifesto of Kassim Aju. And you'll agree with me that other than those children going to work, they have acquired academic qualifications slightly higher than what they would have achieved if they were here in the country. Today they are making a contribution in the global space on matters health. They are making a contribution in terms of remittances to this country. And I want to urge all our young people who benefited from the program, and they know themselves they benefited from the program, that it is in their responsibility and interest to also make sure that that money is refunded, and also support other young people from the county. When the president visited Finland the other day and met the Kenyan community, 80% of those the president met were actually students that went through this program. To demonstrate that what we were doing was actually in line of trying to alleviate the lack of jobs, the lack of opportunities, and reducing the number of youths who are not economically engaged so that their lives can also improve. So I hope the county government will revisit that matter and now make good with the universities that we had relations and the countries. And the governor should have a public apology for politicizing the program, of course escaping and making sure he didn't appear in court, so that our young people can continue the benefit. Otherwise, I don't want to say more than that. And to our supporters, tunasema tuko imara. So, before I finalize, let me just ask my counsel here, Chebon, to just say one or two things.
Fire, see fire! Fire! Moto, see moto!
Thank you so much. Hello. Thank you so much for the support that you have given to the senator. We have been the legal team that we have been burning the midnight oil, prosecuting his case. I want to thank my colleagues for standing and fighting very hard for the senator. The senator has faithfully and diligently submitted himself to the court for the last close to 3 years. Secondly, many people may be asking themselves many questions. It is important that the public knows that the governor of Uasin Gishu County, who was a witness, failed to show up despite several summons issued by the court, despite there being a warrant of arrest. So it is very important that this is a very important case that ought to have helped the people of Uasin Gishu County, but it took a political tangent. As we speak right now, we have firm instructions. We have issued demand letters to parents who have defaulted, who failed to pay the money from the trust. And right now, as we speak, the court has vindicated the senator. And we are going to pursue those who failed to pay the amount of money as required. Thank you so much.
Doubt, as at the close of the prosecution case. I begin with count number 1. On the charge of conspiracy to commit a felony as charged in the first count, the accused argued that the charge could not stand without any evidence of the essential ingredient of common intention and meeting of the minds. The prosecution, on the other hand, argues that a meeting of the mind does not require a formal written agreement or direct communication between the parties. The prosecution, however, relies on the old 1920 English case of Rex versus Maverick, TLR volume 14 at page 421, where in a charge to corrupt police, the English court held as follows, and I quote, "It has been further suggested on behalf of the appellants that a clear distinction ought to have been drawn between two things which, it was alleged, were sharply opposed. On the one hand, a series of individual conspiracies between Goddard and the one other person in each case, and on the other hand, a general conspiracy to which the parties were Goddard and all other persons. It was argued that these two things were mutually exclusively, and no doubt in particular circumstances they might be. When once it was considered that, however, that therefore persons to conspire, it was not necessary that there should be direct communication between each and all of the conspirators. It became necessary to look at the circumstances to see if that argument of mutual exclusiveness was satisfactory. So I beg to differ with the Land Prosecution Council. Our case law and jurisprudence might have developed further than the old English case. The offense of conspiracy to commit a felony is contained in section 393 of the Penal Code, which provide as follows, and I quote again, "Any person who conspires with another to commit any felony or to do any act in any part of the world, which if done in Kenya will be a felony, and which is an offense under the laws in force in the place where it is proposed to be done, is guilty of a felony and is liable, if no other punishment is provided, to imprisonment for 7 years, or if the greatest punishment to which a person convicted of the felony in question is liable is less than imprisonment for 7 years, then to that lesser punishment." In the case of Lawrence Gitau Garani versus Republic, the lady and the Land Prosecution Council submissions, which I adopt as the sole issue for determination at this stage, namely, whether the prosecution, in discharging its burden of proof, had established a prima facie case that requires me to call upon the accused person's hearing to make their defense as required by section 211 of the Criminal Procedure Code. If no such case is established, then I am to act accordingly under section 210 of the CPC and acquit the accused person's hearing as per their respective counts. This was held by Lordship Katiti J, as he then was, of Tanzania High Court in the case of Jonas Mkize versus Republic at page 218 as follows, and I quote, "If it appears to the court that the case is not made out against the accused person sufficiently to require him to make a defense, either in relation to the offense with which he is charged or in relation to any other offense of which, under provisions of section, he is liable to be convicted, he shall dismiss the charge and acquit the accused person." In the case of Anthony Njeri versus Republic, 2006 EKLR, the Court of Appeal of Kenya was surprised by a High Court judge decisions to call upon the appellant to make his defense, even after the judge had expressed himself in a ruling at this stage on a case to answer as follows, and I quote again, "I've considered the evidence before me. The evidence shows that the accused shot the deceased, David Sila Kimuyu, on 18th of July 2002 at Chiromu of University campus within Nairobi area. There is no eyewitness evidence as to how this happened. All witnesses who gave evidence arrived at the scene of crime after the deceased had been shot and had died. This includes the evidence of John Musimi Kamwanza, PW2, who testified that he was with the accused but ran away before the accused shot the deceased dead. The relevant evidence on record which attempts to explain the circumstances under which the shooting took place are on the level of hearsay evidence. The Court of Appeal then commented as follows on appeal. Having expressed himself so conclusively, we find it difficult to understand why the learned judge found it necessary to put the appellant on his defense. Was there a prima facie case to warrant the trial court to call upon the appellant to defend himself? It is a cardinal principle of our law that the onus is on the prosecution to prove his case beyond reasonable doubt, and a prima facie case is not made out if, at the close of prosecution, the case is merely one which, on a full consideration, might possibly be thought sufficient to sustain a conviction. End of quote. So, as submitted by both sides to this trial, the standard of proof as to whether the prosecution has established a prima facie case or not was laid down in the celebrated case of Ramanlal Trambaklal Bhatt versus Republic, 1957 EA 332, where their lordships, Newham, Hawley, President, Sir Ronald Sinclair, Vice President, and Bacon J.A., as they then were, explained the concept at page 334 as follows, and I quote again: the onus is on the prosecution to prove his case beyond reasonable doubt, and a prima facie case is not made out if, at the close of the prosecution, the case is merely one which, on full consideration, might possibly be thought sufficient to sustain a conviction. 2. The question whether there is a case to answer cannot depend only on whether there is some evidence, irrespective of credibility or weight sufficient to put the accused on his defense. A mere scintilla of evidence can never be enough, nor can any amount of worthless, discredited evidence. It may not be easy to define what is meant by a prima facie case, but at least it must mean one on which a reasonable tribunal, properly directing its mind to the law and the evidence, could convict if no conviction is offered by the defense. So the same court in Mibiro alias Musa versus Republic, 1960 EA, at page 196, revisited with approval the Ramanlal case above on the issue of prima facie case. The courts in East Africa, including our own courts, have cited these two cases with relish and for a good reason, because they are good law. So, for example, in the case of Republic versus Kennedy Otieno and 6 others, 1998 EKLR, the High Court of Kenya relied on the above cited authorities, gave a simple explanation of what constitutes a prima facie case. The High Court held that it is a case where there is sufficient evidence upon which the court will convict the accused if no explanation is given. This therefore means that, as at the close of the prosecution's case, and where the burden of proof does not shift to the defense, the prosecution should have laid out a case that can convict the accused, assuming that the accused has no defense in rebuttal. Justice Odunga, in the case of the Republic versus Alex Musau Jimmy, 2022 EKLR, held that an accused person should not be put on his defense in the hope that he may prop up or give life to an otherwise hopeless case, or a case that is dead on arrival. Nyakundi J, on his part, in Republic versus Silas Magongo Onzere, alias Frederick Namema, 2017 EKLR, aptly stated that, and I quote again, where, for example, an accused has not been identified or recognized, and there is absolutely no evidence, whether direct or circumstantial, linking him to the offense, it will be foolhardy to put him on his defense. There is no magic in finding that there is a case to answer, and a case to answer ought only to be found where the prosecution's case on its own may possibly, though not necessarily, succeed. An accused person should not be put on his defense in the hope that he may prop up or give life to an otherwise hopeless case, or a case that is dead on arrival. Defense case is not meant to fill in the gaping gaps in the prosecution's case. It is trite that for a prosecution case to convict, it must meet the evidential threshold of proof. Further, and as aforestated, it is trite law that the standard of proof in criminal cases for purposes of a conviction is beyond reasonable doubt. It is further stressed that in a criminal trial, the burden of proof squarely lies upon the prosecution to prove its case. As correctly stated in the case of Peter Mwangi Karuki versus Republic, 2015 EKLR, the burden of proof does not shift and it remains constant throughout the trial. Further, this burden of proof on the prosecution must be discharged without necessarily weighing or capitalizing on the weaknesses of the defense case. In the case of State of Punjab versus Jagir Singh, 1974, 3 SCC 277, the Indian Supreme Court had this to say, and I quote again, "A criminal trial is not like a fairy tale, wherein one is free to give flight to one's imagination and fantasy. It concerns itself with the question as to whether the accused arraigned at the trial is guilty of the crime with which he is charged. In arriving at the conclusion about guilty of the accused charged with the commission of the crime, the court has to judge the evidence by the yardstick of probabilities, its intrinsic worth, and the animals of witnesses. Every case in the final analysis will have to depend upon its own facts." Justice S. Mutuku in Republic versus Hassan Mohamed Osman, 2013 EKLR, commented as follows, and I quote again, "The burden of proving a criminal case lies with the prosecution and never shifts to the accused unless where the law specifically provides the same. Even where the court calls upon an accused person to testify in his defense, it is not so as to prove himself innocent. Courts do so with a view to allowing an accused person to have his day in court and perhaps adduce evidence that may rebut the prosecution's evidence and raise the much valuable doubt. Even in cases where the defense of insanity or other statutory defense available to an accused person exists, the accused is only required to prove such defense on a balance of probability and not beyond reasonable doubt." So with that in mind, let me make the determination. Having considered each party's case, I consider the following as the main and sole issue for this court's determination: whether all the essential ingredients or elements of the charge had been